The extension of the marriage institution to include homosexual couples has not resolved the conflict in our culture. Indeed, it has intensified it in some areas, as people wonder how the Supreme Court decision will eventually be applied and extended in our culture. The following is offered as an attempt to clarify this conflict and to some extent resolve some of this tension. The Obergefell v. Hodges decision ruled that same-sex couples may exercise the fundamental right to marry. The state may not bar the same-sex couples from marriage on the same terms as accorded to couples of the opposite sex. This decision was made on a 5-4 majority, with 5 of the justices determining that same-sex couples must be afforded equal protection under the law in their suits for marriage, and 4 of the justices determining that it should not have been upon them, an unelected body, to redefine marriage as it has been historically understood, culturally and legally, but that this should have been left to the individual state legislatures. Now, it is important to recognize that this decision specifically refers to the state and its terms, not to individuals, religious individuals, pastors and priests, actually performing marriage ceremonies. Indeed, throughout the decision, it treated marriage as an entirely civil matter, and Justice Kennedy wrote in his decision, religious persons may continue to advocate their beliefs and teach their doctrines and debate with the culture. However, the court made no statement regarding the performing of religious ceremonies or the solemnizing of civil ceremonies, and this is where the lack of clarity becomes a problem, because if marriage is only a civil matter, then one may argue that when a priest or pastor performs a marriage, they are just performing a civil act, a service much like a baker selling a cake or a photographer taking pictures. And if it is only a civil matter, then they might be liable to the law for discriminating based upon sexual orientation, which is one of the legally established bases of discrimination. The problem stems from the fact that legally we do not recognize the separate institutions of civil and religious marriage. See, marriage in the United States, we've long recognized has multiple traditions, but we typically don't have the mental categories of separate institutions. The civil tradition, or the civil institution, regards how our laws treat marriage. It gives assumptions to married partners regarding inheritance claims, economic claims, such as in a divorce, the divorced spouse may make claims of alimony or to assets, making health decisions for the partner, or various other decisions, such as regarding child care, child rearing, schooling, and whatnot. There are many benefits in marriage that are assumed in our matters of law, and this was what was being addressed by the court. However, there is also the religious institution, and for I'm going to speak specifically of Christians here. That's the majority religion in the United States. For them, religious marriage is a picture of the union between Christ and his church. It involves a spiritual partnership, and these aspects of marriage are more important to the religious individual than the civil aspects. Now, we know that these are separate institutions, not just separate traditions, through actual practice here. For example, a Catholic couple, if they find cause to dissolve their marriage, cannot just get a divorce. That may satisfy the civil tradition, but they still count as married in the church until they pursue a religious annulment. They need 2 different acts from 2 different authorities in order to dissolve this marriage. Similarly, when pastors or priests actually perform the marriage, they will invoke both of these authorities, saying a formula such as, by the authority of the state of California, New York, whatever, and more importantly, by the authority of God, I pronounce you man and wife. They are recognizing that they are performing 2 separate services, one civil service and one religious service. However, when we don't have these separate categories in our heads, we create this false dichotomy, this question, is marriage a civil matter or a religious one? And this creates a tug of war, because the non-religious people resent any intrusion of religious definition upon their contracts of marriage. And the religious people are deathly afraid that non-religious people will redefine their practice of marriage. This tension only exists because we think of these as one concept. If we could separate this concept, we could resolve this tension. acknowledging that civil marriage and its changes will only affect civil law and not affect religious practice. Our current conundrum is that our law does not do that. In fact, in the Ninth Circuit Court of Appeals, they flatly declared that there is no religious institution of marriage. They said as a finding of fact that marriage is a civil matter, not a religious one. Now, Justice Alito on the Supreme Court recognized this lack of clarity, as he said, the Oberville versus Hodges decision attempts to reassure those who oppose same-sex marriage that their rights of conscience will be protected. We will soon see whether this proves to be true. I assume that those who cling to the old beliefs will be able to whisper their thoughts in the recesses of their homes, but if they repeat those views in public, they'll risk being labeled as bigots and treated as such by governments. He is concerned with government action against people practicing traditional definitions of religious marriage. Recently, in Oregon, some bakers were fined several $100,000 for refusing to provide a wedding cake for a homosexual couple. Since they were providing a market service in the civil arena, they were declared guilty of practicing discrimination on one of the legally protected bases of discrimination, sexual orientation. Well, when a pastor or priest performs a wedding service, are they in the same category? Are they providing a market service in a civil environment and thus liable to respect the bases of discrimination, or are they providing a religious service that is separate entirely from the civil matter? This is what we need to clarify, and why I would propose the recognition of the Separate Institutions of Marriage Act. This is not a change of existing law so much as a clarification. Whereas the religious institution of marriage was established long before the existence of the United States of America, and its laws regarding the civil institution of marriage within its own legal framework, and whereas religious and civil marriage are distinct institutions established by different authorities and governed by different rules, civil marriage being defined by and governed by the laws of the state, and religious marriage being defined and governed by religious authorities and texts, and whereas the United States of America has no authority to dictate religious practice, nobody would argue with this, I hope, and whereas our historical law and custom is not clearly differentiated between two institutions, resulting in the cultural practice of regarding them as the same thing, and whereas this confusion resulted in the Ninth Circuit Court of Appeals erroneously declaring that marriage is only a civil institution, not a religious one, we would offer the following clarification. It is hereby declared that for the purposes and clarification of all current and future law, that the United States federal government recognizes the distinction between the separate institutions of civil marriage, over which the government has authority, and religious marriage, over which the state has no authority. The implications of this are that all the laws and the government that pertain to marriage pertain to the civil institution only, and carry no power to define, prescribe, or otherwise order the religious marriage rights and practices of the people. And the government, as the civil authority, does define the legal arrangements, benefits, and legal responsibilities for civil marriage, and arbitrates claims made upon such contracts, and the government will not interfere with or prosecute any matter pertaining to religious marriage. Again, this act does not change our law, but it clarifies it and upholds the long-standing traditions that our government has. This should recognize religious freedom and cultural pluralism in our nation. And I think this would resolve a lot of the tensions between people fearing others defining for them their own institution and practices. If you think this would be helpful to our culture and to our law, I recommend that you share this with as many people as possible. Please thumbs up this video to indicate that you prefer some clarification like this be made. If you disagree with it, go ahead and thumbs it down, and then share it anyway so that other people can consider this idea and share it to see if they find it worthwhile as a way to address this very important issue. Thank you very much.